Good afternoon, everybody. I'd like to welcome everyone to session 6 of Valora's Universal Auto Classification Masterclass webinar series, where this afternoon we're talking about data privacy. We'll not only be talking about the difference between data privacy and data security, but also the real-life practical applications on how to implement a security policy and security searching and validation within your own organization. If you have followed us for this 2019 season, this is number 6 in our Universal Auto Classification Masterclass webinar series. So we're very excited. We've got one more left coming up next month, so I encourage you to register for that if you have not already. Now let me introduce our speakers and presenters for today. First up, no stranger to anyone who's been on a call with us before, is Sandra Serkes, who is Valora Technologies CEO. And also joining us today, we have Antigone Peyton, who is a privacy and technology law expert from Cloudigy Law. So Sandy, I will hand it over to you to get us going.
Okay, thank you, Jen. As she said, welcome everybody. We're always delighted to have you here. There's a wonderful diversity of folks out there, both in terms of what you do, the organizations you represent, and the locations that you're logging in from. Not surprisingly, data privacy will mean different things to different folks on this call, so we're looking forward to exploring a lot of angles. You are all on mute, so if you have specific questions, by all means, type them in to the little chat area, and we will track that and try to answer either in real time or at the end. So we do very much encourage your participation. I'm going to let Antigone introduce herself, but I'll let you all know she and I go back, I'm going to say at least 5 years now, Antigone, and I've always been very impressed with her knowledge in this area, as well as her professional and upbeat attitude. So Antigone, tell the world who you are.
Thanks, Sandy. So I think we were actually introduced about 15 years ago, but our paths crossed in earnest about 5 years ago as we started working on these types of data classification problems from wearing our different hats. So my journey to where I am today from an information governance perspective has been circuitous. I am a former scientist turned intellectual property and technology lawyer, and about 20 years ago I started focusing on general IP issues, litigation and counseling focus. That then moved to more of a general technology law focus within, I'd say, the last 8 or so. I've worked at a big firm managing the e-discovery group at a very large multinational IP boutique. I've had my own practice, Cloudigy Law. I've also managed the IP and technology group at a regional law firm in the Virginia area. And other than Cloudigy Law, I also wear a corporate hat. I'm now working on a stealth startup that's spinning out secure communication technologies from a company that provides secure communication solutions to government entities, moving that into the commercial world. So wearing that hat, I'm general counsel and an innovation officer for that entity. So I come from different perspectives, mostly private practice, but now on the corporate side as well as the private practice side, wearing both hats. So I'm very much focused these days on the practical implementation of privacy and security practices. So I think you're going to hear a lot of that flavor from our discussion today. Not so much what is the law and what is the language and how might lawyers interpret it, but really rolling up our sleeves and talking about how you actually implement security and privacy in practice within an organization.
Perfect. That's what we hear from our user base. That's what they want to hear. There are many opportunities to learn about it academically. They're looking for the practical, so perfect. This is what we're going to cover today. First of all, a definition and kind of view on what privacy is versus security, because they tend to get lumped together and they're actually different. We're going to talk about everybody's favorite 4-letter acronyms these days, GDPR and CCPA. And then, as Antigone just said, some very practical strategies about how to get a data privacy practice going, how to get into compliance, what sort of tools to use, and how to really, ultimately, how to use data privacy, if that's the hot button in your organization, to really drive overall information governance. And we will be giving some examples at the end of organizations that have done that. So let's dive in and start with the fundamental differences between data security and data privacy. Antigone, you want to take this one?
Sure. So when we think about data security, we think about things like who has access to information, where does it go, how can it be used, is it shared with third parties, what are the physical and electronic security measures we have around that data, and do they make sense in terms of the sensitivity of that information? So it's really focused on this question of whether there is unauthorized access to data and how data is being handled and whether those measures are reasonable. Data privacy is a different concept, but the two should not be considered separately in their own silos. Data privacy is a concept that's now evolved into a number of regulations, both here and abroad, and it's really around the proper handling of data by an organization. It's generally focused on individuals, not on the type of information, though there are some exceptions, right? So it's about protection of identifying information or sensitive information and how it relates to individuals. So we would just want to level set on that, because often people use those concepts interchangeably. They are different concepts. Reasonable people can differ as to what the appropriate definition of data security is versus data privacy, but the concept I want to make sure everybody takes away from this is you shouldn't think about them as different unrelated disciplines. You need to take an approach where you consider these concepts together when you're thinking about your company's information, how it moves, where it goes, and how it's handled.
Two things that I will add to that is data security, at least here in the US, is a sort of an older concept because we've unfortunately been breached for a number of years now. And so people are just a little more literate on that topic. Data privacy, certainly in the US, is a newer concept. And this notion of your personal data having value and risk to you and to the organizations that are collecting it. So at least here in the US, we're becoming more aware of this concept of data privacy. The other thing that I would point out is that data security tends to be at the file level or even at the firewall level about access to content. So either it's about breaches, either internal or external, or it's about attempts at access. Once we get into data privacy, we're going a little bit deeper. We're going into the actual content of the file. It's not so much did you access a file or not, it's what does the file say? So there's more of a content focus in data privacy, and there's more of a kind of file level firewall layer around data security. And those who've been on this webinar series for some time will recognize that word content, because that's very much where the records and information governance folks are going to play, because it's the content that presents the risk. All right. So unless you've been living under a rock, you have heard probably a number of these terms. Some of them are already in effect, if you did not know that. GDPR, my clicker's not clicking. Come on, clicker, there we go. Went into effect actually last year. And we have some in this country coming right up, don't even blink, notably CCPA. We're going to get into a discussion of GDPR and CCPA. People tend to lump them together, and there are some important differences. But at the highest level, everybody is concerned about data privacy, and if they aren't, then they probably should be. They're sort of missing it. There is a sense I get sometimes in the United States of data privacy as a European issue. That's pretty false, and the tide is definitely turning towards data privacy being everyone's concern, whether at the state level or the federal level. And Antigone, maybe you can speak a little bit to what's happening with those.
Yeah, so another takeaway I want to make sure people understand about this is these privacy and protection frameworks tend to be focused in terms of the scope of subject matter that's covered by each of these laws. They're limited in scope in terms of geographic territory, though sometimes, depending upon who the data relates to, those protections cross borders, and we'll get into that concept more later in the webinar. But when organizations have to think about these privacy frameworks, it gets a little daunting when they start to stack these up. This gets back to the question of how do you take a standard approach, or as standard approach as possible, if you're an organization that's dealing with data that's subject to a number of privacy obligations in a number of countries. You can't have 15 different ways that you undertake your information governance process to try to comply with those privacy regs. So you have to take your baseline based upon the most restrictive generally and go from there so that your people have clear directions on how they implement the privacy laws. So that's one concept, right? So companies that are already working on, and I'm going to call it GDPR readiness for a second. This concept of compliance remains elusive. There's nobody I know who understands perfectly what compliance means, because we have the letter of the law, then we have interpretation from the data protection authorities, which is always changing and enlightening us as to what they think compliance looks like, and that will continue to be a moving target. But ultimately, we want to talk about readiness, right? How do you develop that program? How do you undertake your best efforts to meet the spirit of the laws? And how do you remain agile in terms of implementing slight tweaks to your program as new laws come into effect? So companies, for instance, in the United States that have dealt with information involving children under 13, they've dealt with COPA, and they have already at the federal level significant restrictions on use of information, parental consent around that information, revoking that consent and things of that nature. So privacy is not a new concept in the US at the federal level, but it's getting an awful lot of action at the state level, and our legislature is working on, I will call it tinkering with federal level programs, largely in part because there's not a day goes by that you don't see some sort of breach or violation of consumer trust involving some sort of large technology company that lives in the United States. So that's really driving interest at the federal level and coming up with a more comprehensive federal framework that goes beyond just specific types of data like health data and data about children.
Okay, so in case anyone needed this kind of spelled out for them, or more likely as you all out there go back to your organizations and are making the case for, hey, this data privacy stuff is real, we need to pay attention, we thought we'd prep this slide for you, and you're all going to receive a copy at the end as well. You know, what are the risks? What is the exposure? So we tried to kind of lay that out a little bit for you. The first one being, if you don't have proper data governance and proper kind of analysis of the content you hold, then chances are you don't know what you have, let alone where it is. So very hard to answer the question of, do we have PII? Do we have sensitive data? There's probably an instinct like, yeah, I think so. We probably have some in HR. We probably have some in client records. That's generally not good enough. A sort of gut sense really doesn't cut it here. It has to be explicit where it is, what it is, and then more importantly, how you're actually handling it. Possibly the biggest downside, we can argue what's worse, actual fines or reputational risk. But there's major risk to brands, to company reputations for either allowing lax security or privacy, or kind of intentional head in the sand, really not where you want to be on that end of the reputational risk. And then, as I mentioned, there are hefty, hefty fines. starting certainly with GDPR in the EU, but they're also going to start happening here. When we get to a discussion of CCPA, it'd be interesting, Antigone, if you could maybe project for us what you think the kind of cost, the fines are under that, because we haven't really seen it yet. We won't hold you to it, but I'd love to know what you think as an expert is likely to happen. So here's to give you all a feel. It's not just a threat. There was sort of a sense when GDPR first came out that it was just kind of an empty threat. That has turned out to be a mistaken view. Here are just two cases as an example. There are plenty of others and more coming every minute. I also want to point out that these happen per instance. So if a company is found essentially in violation, then they go into sort of an audit mode where they have to prove on a regular basis for a period of time that they are now complying. And if they fail again, they can be fined again. It's not a one-shot fine if there's kind of willful and intentional misconduct that does not get addressed. So this is pretty significant. Antigone, I don't know if you want to add anything here?
Sure, yeah. So these were two situations where there was a breach involved with a massive amount of customer data. So in the British Airways example, there was data of over 500,000 customers involved in the compromise in 2018 over a period of several months. So the ICO in the UK offered this proposed fine for that particular situation. Marriott's situation involved the loss of 339 million guest records. That was again in 2018. So this goes back to the focus not only on privacy but data security. There were significant issues with the systems that led to these breaches, and the fines were quite significant, but the disclosure of consumer data or the compromise of consumer data was significant. And so this is why we can't think about security and privacy in silos. Good security will support strong privacy programs and vice versa.
So Antigone, we have our first question, and I think that we're going to have a two-viewpoint answer, which is great. I think you are going to give a very legal answer, which is great, and I think I'm going to give a very kind of practical technologist answer. So here is the question. It says, could you please elaborate on how you would go about defining the scope of what constitutes PII? I'll let you go first.
Okay, so there is, of course, language in the statute. So on the GDPR side, it's actually called personal data. It's not PII. On the US side, they talk about personal information. These two concepts are generally regarded in the legal community as covering a different scope. And ultimately, if you're an organization trying to comply with both laws, you have to start to understand what type of information that it lies within the content of your documents might lead you to believe it falls under one or the other definition. So for instance, if you have information that is a social security number in the United States, that's of course PI. And ultimately, if it's subject to GDPR as well, just by living in a European system and being co-mingled with European data, it's going to live under the European regulation as well, just by default on where it lives. The ability to use certain information in a system plus other information to identify an individual, that's very much a concept associated with the European regulation. So it's really this more sophisticated understanding of the connection between these two items that allow you to identify a particular individual who's a European citizen or resident, that then becomes the trigger. It's lovely to hear, I'm sure, that neither the CCPA or GDPR personal data definitions provide a definitive answer on the types of information that would be considered as falling within the purview. It's more of a, here's the concept, here's the philosophy, here's how we get there. So we need to really put our intellectual hat on and get into the data and understand what is living in a combined manner, and then decide whether PI or PD or both, these two definitions, apply to that data. But first we need to understand what the data is, and then we apply this interpretation layer. Sandy, I'll turn it over to you.
Sure, and actually my response is very, very similar to that. Yeah, I would say there are kind of two things that need to start at one end and start at the other end and meet in the middle. One end is the sort of the legal definition. What that's ultimately going to translate into for all of your organizations is the policies that you're going to follow. So a written policy that says, you know, when we encounter this type of data or when we collect this kind of data, this is how we will use it, and this is how we will dispose of it and protect it, and all of those things. So someone with a legal hat on has to do that translation between here's what the law says, and Antigone's right, it's a little mushy, so therefore here's how we're going to interpret it and abide by it in our organization. That's the policy. So that's the sort of kind of left edge of the continuum, if you will. And then the right edge of the continuum is what data do you actually have? For example, one thing of PII is the VIN number, the vehicle identification number in your car, because it's a unique number and it can be tied back to you. So technically a VIN is PII. But most organizations, unless you're a car company or an insurer, are not going to be collecting that information from their staff or from their clients or suppliers. So if you have a kind of a generic policy that says, here's the list of PII, this is what we're going to do, it may not have any bearing to what you actually have. So you want your policy on the one hand to be informed by the law, but on the other hand, you want it to be informed by the data that you actually have, what makes sense. And you might be collecting information that may not show up per se on a PII, bullet list, but given the context and given the other information that you collect would pretty reasonably be considered either PII or more likely personal data. So you have to have these two sides working together, the sort of the legal side and the content analytics side, to come together and say, all right, what are the policies that we're going to live by? All right. So here we go. We thought it would be helpful to lay these side by side for you. And I'm mostly going to let Antigone talk this through because it's her expertise. But the one thing that I will share, which she taught me, to be fair, is the kind of origin or the backstory of these regulations, because they're pretty different. GDPR is really centered around a European notion that personal data is an inalienable right, like in the United States, the right to a fair trial, or the right to be represented as a human being regardless of your race or whatever. In Europe, the right to your privacy is a basic human right. And so the regulations come from that viewpoint, whereas in the United States, not so much on that topic. It's more, the regulations in the United States are more about what's been happening lately and the ire of consumers about being essentially exploited in terms of their personal data. So the genesis and the backstory on CCPA is more about people having the ability to opt out of the selling of their data. It's just a different viewpoint, and it sets the tone for the comparisons. All right.
Yeah, and I'll just add a little more on that. When we think about the birth of the internet and the part that our governmental organizations and then technology and startup companies played, we very much have had this mentality that everything on the internet is free or should be free in the United States, and then these companies had to come up with a plan for actually making money so that they could offer their products or services for free. So in some sense, I think that what has happened with the business model that technology companies use in order to collect, use, and get value out of the consumers has made individuals and their data the centerpiece of their business and revenue making model. So one of the things I always like to tell people is if you're not paying for it and you're not paying a significant amount of money, you are the product, you and your information, you and your behavior. And so if we think about that concept, what Facebook and Google and other companies do and how they use that data and what they charge us for makes perfect sense, right? That's their business revenue model. So that's another piece of the backdrop here in terms of this understanding of the different way that Europe thinks about data privacy and the way that we think about data privacy in the US. Generally, individuals are starting to rethink how they share their information and who they share it with and whether they would rather pay for access to a product so that their information is not going to be sold. But we're just starting to see that movement in terms of philosophy and how people deal with this. So California's law was very much a reaction, a consumer protection reaction, right, to these breaches that we've talked about already during this presentation. You've no doubt seen it in the news on a regular basis. So this law was actually developed over a period of 7 days. It was very, very quickly developed. Lots of errors, lots of information missing from the underlying law. So there was a series of amendments that were submitted in September. There was no opportunity for negotiation for those amendments. It was either an up or down. And so there were a number of amendments that were passed. We now have Attorney General information, a proposed set of regulations implementing CCPA. They are just proposal. We're in a period of public comment. After they receive all those public comments, the Attorney General will then issue final regulations. But guess what? No matter that we haven't had final regulations implementing the law, there's a phased starting line starting from January 1st, 2020 for the California law, which is significant in terms of its breadth and its scope around consumer rights, right? It's focused on consumers. It's not focused on all individuals. It's not focused on business rights. And those enforcement dates will vary, but data breach provisions are going in January. So that's significant when we think about the British Airways and Marriott examples. Those are day one, have to worry about breach and some of the attending fines issues. I also mentioned this earlier, but I think it's worth repeating. There are different understandings of what's protected under GDPR and CCPA. People in the privacy world generally think CCPA has a broader definition of personal information. And interestingly, it involves not only identifying information about consumers, but also it involves obligations around household information or device information. Now, the AG has not given us any guidance on what they mean about device information, so that will be an interesting area that will play out as the law actually goes into effect, so that we understand how some of these differences in the California law will play out in terms of enforcement and further guidance activity.
So go ahead.
Yep, so I'll cover this very quickly because I know we have a lot to cover. So this is something that businesses really struggle with when you have multiple jurisdictions with different regulations and you have to comply with different types of obligations. So I put here a very simple chart of some of the individual rights under the California law and the European law, just by way of example, but there are other laws that we have to worry about, particularly for multinational companies. So one concept is right to rectification under GDPR. This is not a concept under the California law. It's really the right to fix inaccurate accurate personal information that is held about a particular individual. The right to restrict processing or use of the information by a company. Again, that is not a concept under CCPA, but this goes back to this minimization of processing philosophy. And this is important from an information governance perspective, because unless you know how you're using a document within an organization, you really can't implement policies or procedures, whether they're automated or manual, to decide that a document should be deleted or it should go into offline storage for a period of time to comply with the retention record request, and it's not going to live in your online systems. Those types of decisions help with minimization of processing, and reflecting that in policies can demonstrate that a particular corporation is engaging in real business activities designed to minimize processing of personal information or personal data under the European concept. The right to object to processing under the European law. Again, it's the ability to say you cannot use my personal information for particular activities. Objecting to automated decision making, this is really around behavioral decision making, targeting. There's lots of companies that have engaged in business processes or activities around automating routine tasks that often have been done in a manual manner. This is a concept that's more interesting under the European law, but it's not really a focus under the California law. California, the right to access or be informed about what information is held about around you, the right to portability. So this is really interesting in terms of a corporation trying to figure out how to collect information that's housed in a variety of systems and give it to consumers in a manner where the consumer can then take that information and provide it to a third party or use it in some other manner. Right to deletion, and importantly under California law, the right to understand if your data has been sold and the right to opt out of sale of your personal information. Another point I want to make about this before we move on, the timeline for responding to these different types of requests from these different communities is different under the European law versus the California law. So again, when we get back to understanding how corporations comply with these obligations, they need to develop processes that allow them to quickly query their systems, understand where the relevant information lies that is responsive to these individual rights requests, and then do what they're required under the individual regimes to respond to those requests within the period of time that's required under each of the regulations.
So I'll pick up on something right there, Antigone. 45 days may sound like a lot of time, but this is a warning from the technologist on the call. Do not think that you're going to blow through your 200 terabytes of data, finding exactly the PII or the personal data that you need, in a couple of days. That is a massive endeavor. You're talking about probably months of processing time. So this is one of those situations. Do not wait for the first, access request or the first delete my information request to come up before you go, okay, let's go find out where that is, because that's going to take you months and you'll be out of compliance on your first one. So
right, and just to build on that, there's actually a much shorter window for opting out of sale of your personal information. That's 15 days from receipt. And when we talk about consumer information and where it's housed, a lot of these companies have consumer information in a bunch of different systems where they don't think about it until you really start interrogating the data. And then you say, well, we've got some interesting information here. And they say, oh yeah, that's a cloud system where we have some information, but we didn't realize it was consumer information. And a lot of companies forget that their corporate email systems also will contain consumer information. Emails back and forth between the marketing group and another group about a consumer request or a complaint, right? So there's massive systems that we're talking about in some of the less well-known systems within the organization that can house consumer information. So Sandy's point is really, really important. We have to understand where those systems are, what they have, and how to query them and get information out of them before the first request hits the door.
So the second thing I wanted to pick up on was Antigone mentioned lightly, but I kind of want to reiterate it, this notion about kind of dovetailing the analysis for data privacy with the notion of retention. So the policies that you have, most organizations today have some sort of retention plan or retention schedule. We're going to keep these types of documents for this duration of time and under this type of storage and access. Most organizations have that. Whether or not they're in compliance with it, kind of another topic, and in fact part of session 2 or 3 earlier this year. But the point being, you can't make your data privacy policy in a vacuum. It has to be aware of your retention policy, and it's quite likely that one or the other needs to defer to the other one, or at least be aware of it, so that your policies are not conflicting with each other on these things. All right, let's move ahead. So one of the things that you can't help talk about when you're talking about data privacy is this notion of cross-border. In the US, we're a big country. There aren't really restrictions of, let's say, moving information from New York to Florida. But in Europe, and particularly between the Europe and the United States, there are all kinds of regulations and issues related to crossing the border with personal data. Antigone, why don't you speak to this?
Sure. So I'll quickly cover this topic. In order to move data from the EU or even the European Economic Area, the EEA, you have to demonstrate that you are going to engage in reasonable and appropriate measures to protect that data once it leaves the border. And one significant concern at the EU level is governmental access in other countries to data that relates to its citizens or residents. So currently there are 3 ways in which a business can move data from the EU to the United States, for instance. The first one is binding corporate rules. This is most relevant to multinational organizations that have a bunch of subsidiaries in a variety of different countries that engage in business activities, or at least satellite offices at the very least. So this is really an internal rules or policy document that needs to be blessed, importantly, by each data protection authority in each member state in the EU, where there's going to be that movement of data or access to that data or collection of that data. And they have to bless the program and the policy that the business intends to use to continue to protect that data as it moves outside of the EU, either to the US or any other country where the country itself doesn't have adequate privacy protection laws. This is a very arduous process. It takes a long time and it takes a lot of work. So really the companies that are engaging in the binding corporate rules program are big multinational companies like the MasterCards of the world or the Marriotts of the world, right? Standard contractual clauses and privacy shield, I'm seeing more of that, at least at this early stage of compliance efforts. And often the businesses that I work with are using both in terms of a backstop, because both are currently subject to much oversight and litigation, and it's not clear whether either of these programs will continue to be a lawful way to move data from the EU to the US. It's important to note for standard contractual clauses that you can't change the language. You can only add the details about the processing activities. So it's a take it or leave it option in terms of the standard contractual clauses. For Privacy Shield, this is a program that's administered by the Department of Commerce. Your company can self-certify as long as you meet the requisites for Privacy Shield compliance. And again, it's a recognized program for moving data from the EU to the US, as long as you certify and are actually complying with the requirements of Privacy Shield. one thing I'll note here, the statement on your privacy policy that you're Privacy Shield compliant, where you're not actually certified or not compliant, can be a basis for the FTC to go after your company. So it's important, if you're going to make the statement that you're Privacy Shield compliant, that you've actually gone through that process and you're engaging in the appropriate activities to submit to compliance under the Privacy Shield program.
So I'll pick up on that right there, because Valora is actively going through our certification right now. And I will say it's not been so terrible. So if folks are considering getting their Privacy Shield compliance certificate, or whatever it is you get at the end, you're welcome to contact me and we can commiserate through that. I also want to point out, in the past, folks have used Safe Harbor. By and large, Safe Harbor is now defunct and really should be replaced with Privacy Shield. So if your organization is still kind of touting Safe Harbor, you might want to have a chat about that. The other thing that I want, go ahead, Anthony.
Yeah, just more on that. So Safe Harbor has been struck down in the European courts. It is no longer a lawful way to move data from Europe to the US. So I sincerely hope that nobody still has Safe Harbor compliance on their privacy policies or thinks that that is an appropriate program. Privacy Shield was the replacement for that. It was a hasty replacement, but there has been a final adjudication that Safe Harbor is no longer an appropriate program to move to use data from the EU to the US.
As a fun challenge, I challenge you all to investigate the content in your organization and see if you can find the phrase Safe Harbor showing up, because I guarantee you will find it. So, little fun side task for you all. One other thing I want to just kind of point out related to data transfer, cross-border data transfer, is it shows up sometimes where you might not immediately think of it. For example, in M&A. If you are acquiring the assets of an organization that's outside of your country, or that company did business outside of your country, you're very likely going to come up against this. So M&A is kind of a beacon to say, whoa, check into where that data is coming from and how it's going to be used post-acquisition. And the other one that's sort of like that is when you're migrating content to the cloud. We've talked about this before in this webinar series, that the cloud is not a single location, and it's not a pan location that doesn't apply to anyone. Cloud services are actually located in countries. So you may think, oh, I'm putting it on Azure or I'm putting it on AWS. You have to ask the second question of where. Where is that AWS server? Is it in the UK? Is it in Ireland? Is it in the United States? Is it in Japan? Because the cloud, and I'm making air quotes, actually has a country address, and that is going to affect all of these same issues about privacy and cross-border transfer. All right. So in case you are interested in what's been happening, I found this fabulous graphic that was just kind of indicating what had happened in just the span of 2 years. This was an excellent website here on the bottom. If you're looking for more information, I highly recommend you go check that out. It was quite helpful. All right, so how do we do this? How do we get our organization into compliance with data privacy, let's say in the United States? No sweat, just find every piece of personal data you have. Easy, it's just lying around, it's saying here I am. Tag it so you can find it later. Tag every new thing that is ever being born or acquired by your organization, and be able to access it and action it immediately upon a DSAR or any other data request. You've all got this, right? We're done. Probably not. I'm being a little bit facetious here. Bill Murray aside, it's not so easy. No, really. You might want to start with a data map.
So Sandy, on this first part, I think it's critical that people
Antigone, did we just lose you?
Oh, I had a connection issue. Can you hear me now?
We can. We got up to it's critical. And
okay.
it was sort of like the
Yeah, right, right. So I've alluded to this before. It's really important that you understand for all of these privacy programs and for data security, how data comes into your organization, uh, where it moves to, and where it lives in terms of business use. You can't understand that until you understand and build a data map. And part of this can be automated in terms of interrogating the data. Part of it is good old-fashioned interviews and really understanding your network of vendors and relationships around your data. This is the cornerstone to any good security and privacy program. It's not optional. It's also very complicated in terms of making sure that you understand where it's flowing to, who has access, and all of the rest of that, right? That then moves us into policy creation and updates. Once we understand what we have, where it comes from, where it goes, how it's used, we can then create policies around that are really the synthesis of our regulatory obligations around security, privacy, information governance, and our record retention decisions, and how people are actually going to implement those things in practice. These are the synthesis documents that are important to have, not only for ongoing business operations, but also to demonstrate that the company's undertaking meaningful and reasonable efforts to take care of information, engage in appropriate security practices, and engage in appropriate practices around personal data or personal information. Which info is subject to privacy laws? We already had this question before. It's complicated. Part of it is interpretation. I would say generally HR and personnel groups are a great place to start. We also want to make sure we hit the marketing group, right? We want to hit recruiting. We want to hit other groups that may not be first on your to talk to list, but nonetheless have a high likelihood of dealing with either consumer information, if we're talking about the California law, or general employee information, particularly when we're talking about the European law. Which groups are most open to risk? You know, this changes based upon the organizations, but I would say generally the groups where you have heavy employment count, you're not engaging in standard data management activities. You've got content in a bunch of cloud locations. You've got enterprise content. You have a variety of different vendors you're dealing with and no real system to understand and manage who those vendors are. And importantly, if you're in a heavily regulated industry like pharma or financial industry, you've already have a bunch of compliance obligations you have to deal with. Those that are in less regulated industries are probably the ones that are struggling most with these new privacy compliance requirements. And then finally, heavy customer data collection, and I'll also add to that data analytics around massive amounts of data. That's an area where both under US law and under European law, you've got some compliance obligations around privacy and data security that you're going to have to deal with.
Okay, so maybe I'll pick up at this point because we've kind of laid out the picture for you, and by now you clearly understand that there's going to have to be an analysis of the content in your organization. Yes, you might start with the HR and the personnel content, but there's going to be more elsewhere in your organization, particularly if you're subject to GDPR. It can be in many different locations. And the safest thing really is to, I know you're not going to want to hear this, but kind of analyze everything. So part of what we have to kind of face is that our content is everywhere. It lives in different formats. It lives in different locations. Some of it's digitized, some of it's not, some of it's structured, some of it's not. Many of these topics individually we've talked about earlier in this webinar series. So if these are kind of foreign or clunky topics for you, you might want to go back and revisit some of those. For the moment, we're just going to kind of say giant hodgepodge of content. And that it takes us into kind of what it has been sort of happening out in the world. Historically, policies around retention, security, we haven't had so much on data privacy, but a little bit, have been very top down. In other words, the policies are kind of almost created in a vacuum. They're sort of pushed onto employees and told, thou shalt comply. Not a whole lot of training. Definitely not a whole lot of follow through and auditing of that. And as a result, this kind of mushy, not really in compliance, everything is a big old mess. What we're starting to see now is this notion of bottom up and understanding that really these two need to meet in the middle, where the bottom up means start from the basis of the content. What is the content? What type of document? Is it a record? Does it contain sensitive data? And kind of take the decisioning away from individual employees who were never really appropriately trained to manage that in the first place, and kind of centralize that with systems. And that is, of course, what Valora is all about, which is in many ways why we're having this conversation with you all, because previously this was not possible. It was too overwhelming or technologically impossible to understand content, let alone build in decisioning structures around privacy and the treatment of content and the kind of fluctuating needs over time. That has by and large been solved, not just by Valora, but by others, as this is what AI really brings to the table. So what you have now is a kind of meeting of the old guard and the new guard coming together to make both legal informed and content informed decisions. Antigone, I don't know if you
Yes, Sandy, just to add some. Yes, so just to add on that, one thing I see often, people forget how subjective individual views are in terms of trying to create a standard system for classifying and dealing with information. So Sandy and I may have completely different views about whether a particular document is part of a personnel record or it's not part of a personnel record. So I might classify it as a personnel record document as a lawyer. She might classify it as a different type of record under a retention program. So we all have very subjective views about how we consider data, how we store data, how we organize data for our own use. So the struggle that companies have is really coming up with a standard classification lexicon that's then automatically applied at the organization level. And it's also, by the by, making it easier for their people when new information is coming in the door, so that that standard classification is applied to the new information that, let's say, comes in via email, and it might, based upon that classification, be moved to another location. That's the central repository for those types of documents, again, without human decision making and intervention. That's a very powerful place to be in terms of record management and content management. And this is the type of automation and processing that more sophisticated organizations are striving for, not only to make their employees' lives more efficient and to make their record management process more effective, but ultimately to demonstrate a more sophisticated effort to comply with the security, privacy, and information governance policies and programs that they've put in place.
So you guys have seen this slide before. I'm just going to mention it briefly here. Obviously, the linchpin to all of this is auto classification, because it's going to take that burden off of employees and give you that content upward analysis that's so desperately required to be able to comply, yes, with data privacy, but everything else while we're at it. And what we're really talking about is kind of a change in perspective. Just in the groups that are on this call, there are folks from records, there are folks from data privacy, there are just kind of like business line management, there are litigation folks. All of you have a perspective, but what we're really talking about is holistic data management, and data privacy is a piece of it. So we need to kind of get everybody on the same page. That really is the goal or the objective of information governance. And what we're describing here are tools and techniques to do that. One of the things that Antigone and I kind of have talked about in the past is that the current data management approach kind of grew up outside of a lot of regulatory oversight. And now that that keeps coming out fast and furious, most organizations are in this awkward retrofit kind of position, and that's a very tricky thing to do. Again, the policies were built in a vacuum and the data's been stored in these silos. How do we get them all on the same page? Antigone actually used this word earlier. She mentioned reasonableness. For those of you not familiar, there's a concept in the e-discovery world of attempting to kind of right-size the solution so that it is in line with the kind of damages or the scope of the case itself. So the same thing kind of applies here. The larger picture can borrow from that notion of reasonableness. And so, Antigone, I don't know if you want to add anything to this.
The only thing I'll add, I think you covered a lot of good ground. It does take different people with various skill sets to help implement this kind of program in an organization. So the data architects should be working closely with the security professionals and the policy professionals. If you have a records management person or group within the organization, they need to be part of this process. The users, the business groups, right, that you're actually going to implement this program upon, you need to engage in discovery with them to understand how they use their data, how they move their data, what problems are they facing, because ultimately with a good program moving forward, you can make their lives easier. So it's really important to engage in discovery with all of the stakeholders before you just roll out a program, rather than just say, well, we think this is how it should happen from a legal perspective, therefore thou shalt do this. Because sometimes the legal perspective is open to 5 or 6 interpretations, and one is highly aligned with the business activities, and then it's just a business risk structure analysis that the company has to go through. But it's important that you get a wide variety of viewpoints involved in this process early and often. And as Sandy said, you have the right tools to support the activities so that it's not just I think this is what we have and where we have it. We need tools to help validate what the human interviews are providing in terms of information.
Okay, so just a note to everybody out there, we are kind of coming up on the hour. We do have a bit more to cover here. We invite all of you to stay if you can. I think we probably have maybe 5 or 10 more minutes to cover. So Antigone and I will keep going. We hope you guys can stay with us. If not, you know, obviously have a wonderful day, and you will get a copy of the recording and the slides. But hopefully most of you can stay with us and we'll just push forward. So ultimately, when you go to implement a data privacy program, there's a bunch of steps you can take. I'm just going to kind of list them all out here. Antigone, feel free to comment on any of them if you'd like.
Well, I think we've covered all of these concepts before, but I want to briefly talk about the action and the monitor piece here. That's where you're really starting to get traction with your program, where you understand what you have, where you have it, and you can tie in your regulatory responses, like your consumer request responses, through this program and actually automate part of that process, right? So you're applying certain activities to certain sets of data in a wide variety of systems. That is where the program is really going from the infant phase to a sustainable privacy program. And likewise, on the monitor side, privacy compliance and security compliance is not just a one and done situation. It needs to be a living, breathing program. So it's important that this is not just to see what we have yesterday and then going forward we train people and tell them to do the same thing going forward. We need to have these ongoing programs and these systems and these processes set up so that as change happens on the ground in terms of our legal and regulatory obligations, we have the ability to tweak our program change our record retention policies, decide that we're going to consolidate data in 2 or 3 systems into one, and apply those same record retention decisions when that data is migrated to a new system. So all of that is a living, breathing process, not just a push towards an end goal and then we're in the maintenance phase.
So I'm going to just kind of do some of this section lightly because many of you have seen it before, but obviously we are talking about using auto classification to do a lot of this work, both the identification of the type of content you have, for example, document type or record type, as well as the presence of different types of PII or personal data. That also includes sometimes sensitive data that may be neither of those. And then, of course, the disposition or the actioning on that content, both at the outset and over its life cycle. So auto classification really kind of covers the gamut of all of that. For those of you who've never heard that word before or have no idea what that is, it is a software technology. It's algorithms going through and looking at content and finding things like a social security number or a home telephone number or an address inside the type of document that where you would expect to find that information, like this one, which is a loan application, a U.S. loan application form. It's going to be riddled with PII, and so auto classification software is going to be able to identify those things.
Sandy, one thing I'll add here is this is a really important part of the process in terms of being able to get into the content of the document in an automated manner, right? This will take humans millions of years to do this, and they would be inconsistent if they were doing this manually, just like a linear e-discovery review, right? We have lots of information that shows us 2 different people might make different decisions on the same document. But what's helpful about this particular visual is if you have something that's not PII or only in a document or maybe PII, there can be an automated treatment of the document that's different than a document that's riddled with clear PII or PD, right? So you're providing some information back to the system as to how each document should be identified from a regulatory compliance perspective. The system then learns from that and it can auto apply that going forward. And if it meets something confusing going forward, it can present that to the record retention manager for another decision-making process to further educate the system. So this is, again, the value of leveraging technology to help you really implement privacy compliance at the document level.
So what happens when you do this, if you're going to be tagging the content, classification is really the first step. It helps, if you don't have a data map, it can even help you effectively back into a data map because it will ultimately tell you what you have and where it lives. Some folks already have a data map, that's always helpful, but if for some reason you don't or it's out of date, very common, this can actually get you there, which is, as we said earlier, kind of the first step in dealing with this. Let me kind of move ahead. So one of the things that you might want to ask yourself is what kind, and you guys have seen the balloons before, what kind of metadata is useful in different contexts? We've talked about retention metadata, we've talked about litigation metadata, legal hold. Now we're talking about data privacy and data security. It's the same story. As long as you're analyzing the content for one of these issues, analyze for all of them. And so I put it to you guys, think about which attributes and tags are going to help you manage data privacy. You might actually have a field for the type of PII present or the type of personal data present. And again, depending on your organization and the kind of information you collect, and by the way, collecting information, that's not necessarily going out there and explicitly saying, give me your social security number. If you have it anywhere because it's on a form, that counts as collecting. Sometimes people think it has to be this sort of active Q&A to be collection. That's not true. It just has to exist. So if it exists, it's considered collected. And so that's where I would sort of say to you, what kind of information would be A, helpful, and B, required to carry out these type of monitoring going forward. All right, so those of you who sat in on our last session, actually, where we talked in great detail about metadata, you guys know this, that the rich metadata is the key. It is what identifies all of this content in kind of a handy shorthand way. That's what metadata really is. And so your metadata can be oriented around data privacy if that's your pressing concern. Personally, I would recommend you get all of it as long as you're in there. But if data privacy is the thing that's motivating you, so be it. Go ahead and get those data privacy-oriented tags. And that's what will allow you, as Antigone said, to reach that maturity level that says, not only do I know what I have and where it is, I have everything tagged up. So now I can respond to that DSAR or that that request to stop selling my information in the time frame available, because basically what I'm doing is just generating a report or a search and getting the answer within seconds, as opposed to, frankly, weeks. So that's what we mean by operating by facet. If you're not familiar with that term, it's basically like tag. So having that rich metadata going through that auto classification exercise is going to give you the ability to literally operate by facet and operate in an automated fashion. All right, so basically you're going to want to ask yourself these questions and understand that auto classification is going to kind of address each one. I think we've kind of hammered this home. I don't know, Antigone, if there's anything else you want to add?
Nothing other than if you've got all of this figured out within your organization, you are at the top of your class. You're part of the rarefied 1%. This is something that companies are really trying to get their head around with their data and where it's living, whether it's on the LinkedIn site with their job opportunities page, or it's living within a more formal structure within the organization. So this is the ideal on where we can go when we grow up and become real data classifiers.
So we're down to the case studies. I think we can talk about them pretty quickly. This one sort of speaks for itself. This was a Valora client that was, as part of a litigation, looking to redact content that they had so that when they did their production, they would not be providing sensitive data. So it's sort of an early precursor to a notion of data privacy. But it kind of hammers home the ability to use auto classification to solve this kind of problem. One, to identify PII. Two, to auto redact it out. So again, we're talking about software performing redaction, not people. And then three, to create a sort of production friendly set of content, including images, in which the offending information was not only black-lined out, but actually replaced with substitutive content. That's a nice trick when you're looking at personal data. You might replace an actual social security number with the words SSN, the letters SSN, indicating there was a social security number here. We have removed that offending content, but you can have some context as to what was there. So that's kind of a technique for protecting personal data while still giving the general gist that does not violate data privacy.
Yeah, and just to add on this, so this is an e-discovery response context, but the same holds true if we're talking about a data subject access request under the European law or a consumer request under California. We need to be able to get the request, verify the identity of the individual, and under California, the ideal is to compare it against information that's already available about that consumer, which of course means querying your systems to see what data you have, even when you're in the identifying phase of the request response. And then if they are exercising their right to portability, again under the California law, being able to actually pull that underlying data out of the system and put it within a structure that it's easy for them to move it, take it to another organization. So I just think this really screams that companies need to have a more sophisticated process than having IT manually query systems or contact a bunch of vendors to see what kind of reporting or export functions they have. That would be a full-time job for many people within the organization if you're getting a lot of California consumer requests.
Just to echo that, one of the organizations that we work with that has a lot of activity in the EU, they have a team of 15 people whose job is nothing but responding to DSARs from that organization. That is an awful lot of overhead to undertake for a system that can basically be automated. Not surprisingly, that's why we're talking with them. But it's something for people to think about, because CCPA is coming down on everyone here in the US. You know, what is going to be your solution? The ignore it is really not a choice. So are you going to be, you know, essentially implementing a giant search and data entry and manual redaction type of service bureau one way or another? Or are you going to use technology to help you out of it? So those are really the choices. Do nothing is not really a choice. All right, so we're kind of coming to the very end here. Where and how you start. We strongly recommend that you start with a pilot. We've talked about this before, which is to get a smaller set of data, a group that is kind of pro automation, that is willing to kind of serve as a guinea pig, and start out with a simple, data privacy exercise, literally analyzing the content and seeing what you have. We strongly recommend you start maybe somewhere in personnel, perhaps with departed employee files, since nobody seems to ever own those. You'll get a lot less pushback, so we recommend something like that. Running auto classification to see what you have and where you might be exposed, and how you can kind of handle that content, particularly against retention. If those folks have left the organization, what of that can you get rid of confidently within your policies? So again, these things dovetailing together. Run a pilot and get benchmarks. In other words, how much of the information was accurate, how much of it was kind of covered, what we call precision and recall, how much guidance did you need from a subject matter expert, how quickly did this kind of content process. All of this will help you build out your ultimate use case on what you need kind of across the board. And, again, start building that ROI. Often the ROI around data privacy is the comparison of not doing this. What is the scope and likelihood of fines? What is the cost if you were to do it by hand with a sort of a captive or outsourced service team? And what's the exposure, kind of litigation exposure of not, either litigation or fines, of not complying. And then once you kind of get that up and running, make sure you showcase that across the board. This is where you're going to get that cross buy-in from all these other groups. There are lots of different groups and teams in the organization that have a need to get their arms around the data. You are not alone in the data privacy camp.
Sandy, I just want to add two things here. One, in terms of doing this preparation, I think it's important to undertake what's called tabletop exercises, where you literally get people in a room and say, okay, we have this request. How are you going to comply with it? What are you going to do? What systems? All of that fun stuff. That's always eye-opening to an organization. And it's really an exercise on a test case to see how you will be able to functionally respond. It also highlights areas of weakness, lack of education about particular issues, and a variety of other things that the organization can then be tasked to work on. And in terms of the spread the word, education is very important in terms of individual users within the organization. A high priority in terms of education is certainly the C-suite in terms of risk mitigation, so that they buy in and you have a top-down buy-in approach in terms of these programs and the spend and the effort that it's going to take to undertake efforts to be first day compliant or ready for the privacy program requirements. And then the other part is focusing with more detailed education on your user groups that you think are likely to have the highest hits in terms of compliance obligations. So perhaps it's marketing, HR, payroll, personnel, finance, and then some basic level education for others, maybe as part of their onboarding process, and then helping them understand changes in the law that affect their everyday activity. So education is not a one-size-fits-all, but it is really valuable for people not only to understand what you're doing it, but why you're doing it. Because people want to generally do the right thing, but unless they understand why this is so important to the organization, they're much less likely to comply with the program and the requirements that have been put in place.
All right, that kind of brings us into the end. These are some excellent places to find more information. We haven't talked about IAPP. It's free to join. I strongly recommend it if you're interested in these topics. You will get a lot of email, I'll warn you right now, but it's generally on point and very helpful. We discussed the Privacy Shield framework. Here's more information. And if you're not familiar with NIST, I strongly recommend you become so. They are really trying to make industry norms of all of these topics, and so they've built a privacy framework that's very helpful. And then finally, we are coming to the near end of our webinar series. We've covered every topic on here. This was the last one today. We strongly hope that you will join us to our very last session this year, which is the wrap up of all the sessions together. We're going to try and have every single other presenter and some other goodies for you folks joining us as a master panel. So we hope you will join us on the 11th. Antigone and I will stick around for questions if folks have Q&A. And we very much thank you for joining us today and staying over to learn some more. Thanks and have a great day, everybody. Feel free to send us questions. We'll be on for a couple minutes. All right, not seeing any questions come in, so I think we're going to go ahead and end the session. Thanks again, everybody. Take care. Bye-bye.